Well, I guess I'm gonna get started. The When Brooke asked me to host this chat, it seemed like a good idea at the time, but as time starts approaching, then it's funny how those things go. What I think is still pretty helpful is for us to sort of go around the room, so to speak, and introduce ourselves, our courts. And I thought it would be fun for y'all to tell me what the temperature and weather is like outside where you are. Uh, but my name is Marc D'Antonio. I'm the Muscogee County Probate Court judge. Um, with the and I've the current temperature outside is 68 degrees and partly cloudy. Uh, Magistrate Brown, you were quick to come on the thing, so why don't you introduce yourself?
Thank you, Judge. My name is Magistrate Chris Brown. I'm from the Claremont County Probate Juvenile Court, which is the county east of Cincinnati. It is a balmy 52 degrees and sunny, but we are anticipating snow this evening. About 1 to 2 inches of snow anticipated overnight. So we have the typical Ohio weather system of wake up. If you don't like the weather, give it 24 hours, it'll change for you.
Okay, and Judge Hassel, is the weather that different from where you are from Columbus or?
Quite a bit. I'm Scott Hassel, I'm Judge of Probate for Etowah County, Alabama. We're 3 hours west of Atlanta, an hour south of Huntsville, an hour north of Birmingham, and it is partly cloudy. I had to look on the thing. My windows are a little foggy, so I can't tell. It's 63 degrees here in Alabama today.
Well, and Susan, what's it like in Athens, Clark?
It is currently 62 degrees and cloudy. And I'm Judge Susan Schaefer. I'm the probate judge in Athens, Clark County, Georgia. Go Dogs.
And Magistrate, is it Juza?
Correct, Judge. My name is Tom Duza, and I am the magistrate in Erie County Common Pleas Court, which is a weird court because we have exclusive probate jurisdiction. I am the judicial officer that handles our AOT court. Chris may be in the same state, but we are miles apart when it comes to weather. I am up on the lake. It is currently 41 and sunny and going to get worse. So just what it is in Ohio, as we said.
Okay, and I'm going to assume the next person is Judge Milton Mack.
That'd be correct. From Wayne County, Michigan, where Detroit's located. It's currently 32 and sunny, balmy.
And Judge Brown.
Hi, I'm Elaine Brown. I'm here in Hayes County, Texas. It's 81 degrees and sunny here. And I'm the judge of County Court at Law number 3. And I have general jurisdiction, which means I do probates, guardianships, civil, criminal, you name it.
Okay, and Judge Powell or Hearing Officer Powell, I'm not sure what your title is these days.
Hearing officer. Hello, everyone. I am Deetria Carter Powell, and I am a judicial hearing officer here in Fulton County Probate Court, and it is 62 degrees.
Okay, and Judge Nolter. By the way, I have had a bunch of eye surgeries. That's why I'm wearing a hat, even on the bench, and that's also why I might be leaning in and staring a little bit on the screen. So I apologize. But tell us the temperature where you are, Judge Nolter.
It's 75 and sunny in North Texas. My name's Ed Nolter. I'm the associate judge for the Denton County Probate Court. I do all of our involuntary commitment hearings, and I run our AOT program.
Okay, and then I think Steve Eberts, is that correct?
That is correct. Thank you. I'm the chief judge at the Shawnee County District Court in Topeka, Kansas. It's 64, and maybe you can see a little bit of overcast. And I am similar to Judge Brown. I'm a general jurisdiction judge, and I have a grand jury who is deliberating, so I might have to jump off here if I'm called. Okay, sorry about that. Thank you.
Okay. And well, Judge Riddle, temperature is probably the same in Cobb County as it is in Fulton.
It is. We're 1 degree cooler. It's 61 degrees and cloudy.
And you're the associate judge in Cobb County, Georgia.
County.
Associate probate judge. Okay, and Judge Golian. I apologize for,
That's all right. Is that me, Scanlon?
yeah.
Yeah. I'm in Marion County, Indianapolis, Indiana. So similar to Ohio, it's gorgeous. I've got the window open. It's, I don't know, 50-ish, but a little windy. I am senior judge now. When I was a magistrate, most recently, I had family. I did most all family cases, but prior to that, was in probate court for about 3 years and handled involuntary civil commitment hearings there. And we've been working. I assist Indiana's Office of Behavioral Health, and we are currently working on an AOT. Pilot program where we have about 10 counties working together to stand up pilot programs. 3 existing counties already had them, 7 we brought in. And so TAC has been working with us on that. So
That's great to hear. Judge Shannon?
Hi, I'm a magistrate at Montgomery County Probate Court in Dayton, Ohio. I'm one of 2 magistrates at the probate court, and it's just probate division. And I'm one of 2 that do the AOT docket. And
Okay.
it is sunny and I think 50 degrees out, so I'll take it.
Okay. Judge Lewis, I think your camera's off, but
Oh, it is. How do I? Well, let's see. Is it on now or?
you moved around on it, but no, it's okay.
Oh, let's see. Well, I'm not. It usually works, but no, I can.
Well, anyway, you're Wes Lewis.
West Lewis here in Moultrie, Georgia. We're about an hour north of Tallahassee, and before, well, a little humor before we start the meeting. I was just looking over. We do probate, and I had an objection from a disgruntled son and said that he was cut out of the will and said his dad killed a man and left him. There's a place where we can find the dead body. So I'm going to turn that over to the sheriff's department and see if there's any validity to it. But anyway, we do an AOT court here. I will try to get the camera going where I can see you fine folks. And again, we're kind of a rural county, about 45,000 population.
And what's the temperature there?
It's 70, but I left the house this morning, Judge, and it's got a cold for I'm like, why did I leave my jacket in the house? But yeah, it'll be warm. We get 20 minutes of winter here, so about 18 minutes are up. We got about 2 more minutes before it's March. So
Okay, and the people on the screen are moving or keep bouncing around. Adam Reinhart. Introduce
So it's
yourself.
magistrate, and I'm in Union County in Ohio, near Marysville, Ohio, if you know where that is, famous for Honda. It's about 50 degrees here, and so primarily probate is what I do. I also help run the court here, so we don't have very many cases. Actually have one, and going to get a second one. So enjoying the slow pace currently.
All righty. Is it Denotra Gunther? As I said,
It is Denotra Gunther. Good afternoon. I'm Judge Denotra Gunther. I am in district court in Fayette County, Kentucky, which is Lexington, the University of Kentucky. I am a general jurisdiction judge. There's 5 of us in this particular court, and I am the one who started our AOT court. And it is actually the fastest growing AOT court in the state, and our AOT court is statutory. The weather is about 50 degrees here, but give it about 5 minutes, it could be 80 or it could be 20 below.
Yeah, it does seem like that. We all know who Brooke Gentry is, and she said she wanted to stay on the down low on this matter. And so I guess, is it Eliza? You're going to have to, I'm just butchering. Is it
Elise?
Hi, how are you?
Good, and I'm trying to play young. My name is Cecil, and you haven't heard of it.
Kind of hard to understand you.
You can't hear me?
Well,
My apologies. I'll try to fix the volume.
okay, well, Is there anyone else that hasn't had an opportunity to introduce themselves?
Hi,
I'm
this
Eleanor
is
Stormer
Marina.
from Ohio. It's real feel 25 degrees. I just got finished with an AOT court with 75 people in it. So happy to learn about how y'all are doing things.
Wow, I don't ever have that. I don't think I could get through 75 folks in the way we do our
Well,
AOT hearings here.
they're not all allowed to come at the same time. There were probably like 20 to 25 of the 75 here today with us.
Yeah, in terms of how I do things, we have probably there's about 50 folks in AOT in our on one way or another with it, but I usually have less than 10 folks come see me on any given day. Um, and actually maybe it ties into what we're going to talk about. I don't know how I could do it or be effective with the time constraints and all of those things. Um, and I really want to make sure I don't just dominate this conversation, but I do think I need to at least talk a little bit about why I'm doing what I'm doing today. Um, I've been certified, the state of Georgia
Hola,
contracted
esta
with,
llamada está siendo traducida y subtitulada en
well, go
tiempo
ahead and
real.
silence. Yeah, if I can. There we go. Anyway, I was saying that the state of Georgia did contract with Dr. Amador, and a number of us have gone through train the trainer. So I am certified to teach LEAP, but I think that that's way beyond the scope of what we're really here for today, and also wouldn't really work with the time constraints we have. Plus, with Dr. Amador, you can hear it from the horse's mouth, so to speak, better than the way I would probably do it. By a show of hands, how many of you have never heard of LEAP? Okay. Well, then I'm going to share my first slide. And hopefully you all can see that. This, what I would recommend for some of you that this is a very interesting new learning thing is I would say you should go to the Leap Institute's website. It's leapinstitute.org. This is their cover page. There's a number of things that it can get out of that. I'd encourage y'all to watch some of the videos. It's very helpful. There's a number of interactive things. When I have families that come to me where they want me to have someone apprehended because they are having some episodes related to their mental illness, but I don't think that they're necessarily in crisis, and therefore I'm not agreeing to sign the order to apprehend. I often send families to this website so that they can at least learn some of the language about how to talk to their loved one that has anosognosia. As I said, I think there's a way of, and maybe Brooke can put that link in the chat, since given my blindness, that typing into chats and stuff isn't really very helpful for me. But I am going to talk a little bit about assuming that there's some knowledge of it. And I'm trying to think of what other things I want to say. Well, let me tell you a little bit more about my introduction to LEAP and why I think it is something helpful to do in court. I started working in the probate court in 2006 with my predecessor. And in Columbus, Georgia, we have a state psychiatric hospital. We also have a private psychiatric hospital, and we have two different outpatient providers. So, although a lot of my cases were the state hospital cases initially, and I would be sitting in court and would often hear the psychiatrist say that the symptoms that the individual was displaying that proved they had schizophrenia was their poor insight into their illness. And that just bothered me. I intuitively, it seemed to me that this just didn't make any sense. That's kind of really circular reasoning, right? Because from the point of view of the patient, if you're not sick, Why would you have insight into an illness that you don't have? Um, in fact, I think um, it, it, it just wouldn't make any sense to me. And you would probably never develop that insight because you're not sick. So, fast forward, have been wanting and was excited when uh, state of Georgia got more involved with TAC because I've always wondered a lot of the practices I've been doing for years, whether they were best practices. And I attended the TAC seminar or it was the TAC AOT symposium in San Antonio a number of years ago, and that's where Dr. Amador spoke. And I had a bit of an aha moment because, as I said, I was in a situation where why would this person gain insight when they're not sick? Um, and that really, when I was in court, a lot of those times it just put the doctor and the respondent at loggerheads. With Dr. Amasor's insights, pardon the pun, into anosognosia, which is a fancy word for lack of insight, what he articulated, it made sense and it finally helped gel what I had been thinking all along. So that actually I found to be really, really helpful. Um, Let me ask another question real quickly. Um, how many of you have tried to use leap techniques while in court? Oh, good. So I'm glad to hear that. That way I won't have to do a lot of the talking. Again, I'm trying not to well, we're not, as I said, teaching LEAP today, but I thought it does make sense to have a little bit of an overview of what LEAP is, or what the tools are: listen, empathize, agree, partner, delay opinions, apologize. I do a lot of apologizing and delaying. Um, but here are the LEAP tools that we are going to talk about in some detail. One of the tools that I think is the most important is really listening in a non-judgmental way to get started with individuals. I'm going to stop sharing. Um, because, like I said, it really, to me, what I've learned through LEAP is that it's really about building relationships. Um, And in order to build those relationships, you really have to make the individual feel safe. Um, and so let me ask you all this. How many of you think court is a good place for many of the AOT respondents coming to you where they just feel safe walking in the door the first time? I don't think any of mine do either. If anything, court and safe and non-judgmental is not usually where the individuals that are appearing for me expect court to be. Most of the respondents that have interacted with the criminal justice system don't think they're coming into a place where they're safe or that they would be allowed to safely speak their mind. Um, and by definition, court's judgmental, right? So those are sort of some barriers, I think, in terms of from a court perspective about trying to use LEAP in court. Um, that can be an obstacle for the individuals with anosognosia from their point of view. How about from the judge's point of view? I got another question I want someone to answer. Can a judge be friends on a professional level with a respondent or defendant? Anyone want to answer that one?
So I guess it would depend on what you would consider the definition of friend. I can be friendly. I don't know. A friend to me, we're gonna hang out and eat supper. We're gonna grill ribs on the barbecue on the grill or something. Uh, Being friendly. It depends on the definition. I think if it's a professional, meaningful relationship where maybe an accountability partner, they see the court as the person that's going to support and encourage them, not just chastise them, then perhaps that would be if that's called a friend, I guess that's possible.
Anyone else think that that's possible or not? No one?
This is Marina Sabet. Hello?
Yeah, we can hear you.
Okay, this is Marina Sabet, actually from Maryland. I apologize. I had my translate button on before. That was the weird noise you heard. I'm actually a judge in Maryland. We're about to roll out AOT in July. So my point of reference on this is not from AOT, but more from problem-solving courts. And I assume by what you mean by friend is that you take an interest in the person's well-being, and that you, as you had said with the LEAP method, you partner with them in a way that makes them feel as though someone cares about the outcome, and that is not a traditional type of interaction that you would have in a normal court scenario. So if that's what you mean by friend in sort of the problem-solving court context, then absolutely, I think you can have that different kind of relationship.
And I actually think of my AOT court and actually a lot of things I do in probate court, including guardianships and that, as problem-solving court. So
I'm a former therapist, and it's really important to keep good boundaries with these participants in AOT court. In my opinion, I also run the mental health court. I think boundaries are so important. They will test them every time. Yes, you can be pleasant, you can be kind, you cannot be their friend.
well, I think it probably depends, going back to Judge Hassel about that, how you define friend. Some of the individuals that have come before me, I've now known them for a 5, maybe some even longer than that. So we are at least friends in terms of we know something about each other. And to me, it really is about building that relationship. Yeah, I do agree with you. There always should be boundaries. But but at least from my experiences, if I'm really going to be able to build a relationship in order to help an individual appearing before me become more adherent to taking a long-acting injectable, I have to put down some of my guard about those kind of things. Or at least, I don't know. It's clearly taking judges out of what I would consider your comfort zone. For that matter, the first time I have a new attorney in court that has never seen me use any kind of reflective listening, it freaks them out. I've had another attorney have to explain to him, oh no, he's not agreeing with the respondent here. He's just reflectively listening to them. But I do think that there's some questions about coming out of your comfort zone. But I also, well, I put it a different way in terms of about being friends. Is it okay to care about the person?
Of course, I always cared about my clients when I was practicing counseling. I care about the participants in both my courts. That's different from being their friend to me.
Okay. But I mean, are you all comfortable? I mean, I was had a number of other sort of ways I was thinking about this. Um, does do you have to, in court, does a judge have to come across as authoritative and confident? Anyone?
For me, that's the challenge of AOT. If you come out of the gate, I think strong and harsh, the black robe effect, then you've played all your cards right out of the gate. I think if you approach it from a problem-solving perspective early on, where you're more of an encourager, you're identifying issues, how can we get there? How can we find success? How can we find common ground? What can we agree on? Then you've always got the backup of the black robe. But if you come out being, how you would handle an estate or another adversarial type case, I think has to be different. You ask about utilizing LEAP. I've actually, Judge, got to the point where, just for me personally, that little handout you have, I condensed it down and I've taped it. It's sitting on the bench in my courtroom to remind me, because sometimes you'll get sucked into that client's. They'll be going on, and it's easy to get wrapped up in that. And just to remind me that, okay, let's take it step by step.
Right. And I'll tell you, probably one of my greatest success stories using LEAP involved an individual that had very little understanding of his illness and had not taken his medications for up to, well, we were going on 4 or 5 months. He was fast decompensating to the point that he was attacking some of the appliances in the semi-independent living he was in, and he was going to have to be stepped up to a higher level of of supports that he really didn't want. And the recommendation was that they were willing to let him stay where he was if he would try taking an injection of, when it was in Vegas, Sustaina at that point. Our ACT team literally came to court with a shot. And I spent probably an hour building a rapport with him, reflective listening. We both agreed that going to that higher level of housing was not something either one of us wanted him to do. Maybe, and here's where I go back to the friendship and maybe boundaries and things like that. He was very close to agreeing to take his shot. And what I think finally pushed him over the edge was I said, well, how about this? If you're willing to try your shot, and I know you're worried about a lot of the side effects, I'll go to lunch with you next week so we can talk about the side effects. And he took his shot. And now, professional boundary wise, we had lunch in the courtroom. And he still had somebody with him that I also bought lunch for that day. And over the course of a 4-month period, we had lunch every month. He has, and he actually, I don't believe in people graduating from AOT, since sometimes we maybe even have like what I would call letting the court order expire silently, to not necessarily, but anyway, he has been out of a court mandate for over a year and a half now, still continues to take his medications. I did go out of, he's now living about an hour and a half south of here, but I went out of my way and I did have lunch with him once. And I still will take a phone call just to talk about how, even in that context, yes, we're friends. I consider him a friend, but my questions are usually oriented to how do we continue to move forward in terms of your individualized service plan? What progress are we making? What's your next goal here? So I continue to have that relationship, whether or not that's over the scope, or actually, I'd be curious to hear, Judge Brown, whether you think from a therapeutic point of view, if that's.
Can I just interrupt before we get to that? Because, that's not a friend. A friend is someone you'll make bond for at 1 a.m. Right? I mean, that's what a friend is. You have a collegial relationship with someone who benefits from your interest. And I think that's the best thing that we can give to the people who are the participants, which is we are genuinely interested in their progress. We genuinely want them to be successful. And I think that comes through. There are courts that have lots of opportunities for judges to interact in a social way with participants. Judge Liu in Reno is one of the first ones that I know, where they get together and they have these little picnics and things. I personally am very reluctant to do that, but I will tell you my program is pushing for that, because they want to have the people see me as human. And I'm like, I'm not really human, I'm a judge. So we are still negotiating what that's going to look like for them. But, what you're talking about is a guy who you are mentoring. You stand in the shoes of, parente parens, or whatever that thing is, parens patria, whatever it is, when we're standing in the shoes of the parent. And I do think there's a distinction there, that we can be comfortable being judges and interested, and we make decisions in people's best interests all the time. So if you're talking to him and taking him to lunch, I think that's lovely. I personally do not want to eat lunch with my participants, but I'm trying to work on that because other people are telling me I should.
Well,
so maybe the counselor can help us on that, on my therapy, on whether or not I should be having lunch with all these people.
That is spot on when it comes to friendships. It's a two-way street. So I imagine you're not sharing a lot of your personal struggles or issues that you might have with these individuals. They're sharing them with you. That's a one-way street.
Well,
You're giving
actually,
them support, but friends, it's a two-way street. And I think that's where some confusion can come in.
well, and I actually do worry about this. To be honest with you, I do make myself fairly vulnerable. I am like one of the things with Leap is being comfortable saying I could be wrong. How many of you, when issuing an order, are comfortable saying, well, I could be wrong?
Mm.
In fact, I'm often when I'm committing somebody to 1 year of involuntary outpatient treatment, I'm often very apologetic about it. I'm also saying, well, I could be wrong, but I've heard this evidence and and I have to apply the law as I see it. And I'm sorry. I hope we can still, well, I would say even still be friends. I think friend is a interesting term. It definitely a professional friendship. I'm not going hanging out with folks, but in terms of sharing stuff, what I have found in terms of really getting a person to open up and listen to me is I will tell them stuff about me. For example, that individual well, actually, he's now in Cordele, Georgia. He knows that I was in special ed. Uh, I I'm dyslexic. I was in special ed for a number of years, and I thought by actually revealing that part about me, and I was really doing it in the context of saying it's okay to have a mental illness. It's okay to be different from other people, was the context. But again, part of the reason I wanted to do this chat was to see if you all think just I'm out of my mind doing these things. Anyone, go
I don't
ahead.
think that, yeah, I was going to say, I don't think there's any problem with being somewhat vulnerable or showing a person that you have created a sort of a safe space for them and a mechanism and a community that they may never have had before. I think that it's interesting. It's kind of like, what's the old pornography, you know it when you see it kind of thing. It's like there are lines that I think all of us probably have those lines, what we're comfortable with and what we're not. But creating a sort of nurturing environment, and as long as they know, though, that, I mean, in Maryland, we don't even have, all we have is the power of the robe. We don't have any type of contempt. We can't just flip it into a involuntary. It's strictly, you either do it or you don't. There are certain things that we can be doing, but I think nurturing that relationship is really all we got. And it's what carries the day in our mental health courts and our problem solving courts and recovery courts. And I think it's probably what carries the day here. I don't think there's anything wrong with what you did to share that with him. I think that just shows you're human. I do think judges are a little human. I have to take exception to that. I think that's what makes us feel and have people be at their best when they appear before us. As opposed to, I'm a judge who believes that even in non-problem solving context, that in order for a person to present their best case, I have to at least create an environment that invites that, not to intimidate them, not to make them feel bad about themselves or small or less than what I'm doing high up on a bench. So I think what you're doing is great. I actually, the one thing I have, and I just want to just kind of toss this out there quickly, is that some behavioral health professionals have taken exception to the term lack of insight because it implies that somehow they could get insight. And I don't know that we want to go off on that tangent, but I found that
I agree with you
with
about
me.
I could definitely see how lack of insight might not be the best way of describing anosognosia. But and so does anyone else have any thoughts about this relationship building, whether you were calling it a professional
Yeah,
caring?
I do. I mean, I agree with, and I don't see a name there, but I agree with the comments of that, of the last judge that was speaking. But I would say, I mean, I think it's important to show compassion. I think it's okay on a case by case basis after you've kind of sussed it out to share some personal things. I mean, I think anything we can do that we feel is within our professional boundaries is to make our litigants comfortable. I think we ought to, and frankly, I think not enough judges, judicial officers do that. But my concern again would be if you're developing that kind of a relationship that you're describing, and I'm glad that that's worked out for you and the people you've developed those
Or that
relationships with.
yeah.
Yeah, or that individual or others. But I think to Judge Brown's point, I think that it's a slippery slope, right? And if you're using the word friend with that person, then again, what do you do if that person shows up at your house at noon on Saturday or at 2 a.m. on Thursday? I mean, if that's my friend, I'm going to let them in. What do you need? But if that's a litigant who, by the way, also struggles with mental health issues, that's probably not what I'm going to do. And so I just think you got to be careful because you can't always control how the other, you can, and we can in our minds define what friend means, but that doesn't mean we know what they think it means. And so I just think that maybe it's a nomenclature issue, but I think you have to be careful with that.
Well, I think that's a very good point. I told you about my success story. I've also actually effectively used Leap for folks that are in a hospital setting, and really it was about I find myself my hearings being more about helping facilitate discharge than it is about committing folks to the hospital sometimes. This person didn't have any identification, and using some reflective listening, I was the first person to listen to her, is the way she put it, and really it was really about just getting her to help cooperate on helping her get ID before she got discharged. But that I knew, and she was being discharged to another part of the state. My vibes went up there that this was not somebody I was going to be going to lunch with. I think and in fact, actually, I will get random emails from different parts of the state sometimes from her that, because she felt we had more of that. Well, I don't know, but so I do think that you really have to look at all of these cases on a case by case basis. And that sort of brings up another issue that when I found it hard to do Leap is when I just don't have the time. If you don't have the time to at least with that initial rapport about reflective listening, if I've got a big old docket or something else going on, sometimes I might try to rush this technique, and it does not work if you're rushing. I have to come across as I am generally interested in learning about the individual, and listening for their emotions. I don't know. I guess the other thing from a therapist point of view is you're not supposed to collude with the delusion. And I do hear a lot of, at least folks, until they understand that I'm not, by just reflectively listening to them, I'm not agreeing with them. But it sometimes does seem to come across like that. And like I said, if a new guardian ad litem or a new attorney there that hears that, it's sometimes a little disconcerting for them. I'd like to hear from some of the other judges that have tried to use Leap in court to hear about what their experiences were in terms of encouraging adherence or some pitfalls or things that you have had come up with that would be helpful for me to learn about and others too. Anyone? I know some folks raised their hand saying they'd use Leap techniques.
Maybe I'll jump in here, Milton Mack from Michigan. And our approach seems to be a lot different than what I'm hearing. We typically do not have a review hearing. In Michigan now, the petitions for AOT come in front of us as part of a combined order that people are already in the hospital. So there'll be a petition for treatment, which will include a period of hospitalization followed by assisted outpatient treatment. And that's really the standard practice now. So, for example, between 2020 and 2024, we've issued over 30,000 AOT orders. And the vast majority of the people on AOT are compliant with treatment, so they don't need to come and see the judge. So we don't treat it like a problem-solving court. It's a civil proceeding, basically. For those who are non-compliant, then we have a review. But for example, Genesee County population 400,000 has 800 people on AOT. They have 90% compliant with treatment. So, uh, the process we use is basically, if there's trouble, come and see us. If there's no trouble, we don't need to see you.
Well,
So
you have a different system of funding too, if I'm not mistaken, Judge Mack. I mean, most of us who are on this actually have a court where people come before us and we're kind of like life coaches for them. I mean,
Right.
that's kind of how I would put it. So we acknowledge what they tell us. You know, if you have a system where you have other people who can encourage them to stay on their medicine, I applaud that. We just don't have that in Ohio. It's down to the judges to do that, unfortunately. And I don't know about the other states, but you know, if they didn't have us, they wouldn't have anybody attempting a holistic approach to helping them, you know, into recovery and to stay in recovery. And my sense is that some of the people here, that's what we're stuck doing. I actually love it, to be honest with you. I'm not really stuck doing it. And I do tell people I'm on thyroid medicine and have to take it every day for the rest of my life. So
well, and
I
Judge
hope
Mack,
that's not a boundary I've crossed.
Right.
I do issue a number of assisted outpatient orders, sort of strapped onto a period of inpatient treatment. But where I will have although, and maybe this is different, is the hospital also going to be the individual's provider when they're discharged?
No.
Okay, so what I will do then is because the providers are usually going to be providers here, is I will order a status review 30 days after the person's discharged from the hospital. Again, every case is different, but as a general rule, because I want to really make sure that there's been a clean handoff between the hospital provider and the outpatient provider. Sometimes the outpatient providers might not even know that there is an assisted outpatient treatment order accompanying that. Also, sometimes the individual, while they're in the hospital, are still a little bit too sick to have the full understanding that they're under a court order. So I use, and in fact, going more to the problem solving collaborative aspects of it, sometimes even when we're working on discharge from a hospital, by convening a status review, I can keep pressure on different case workers and other folks that are supposed to be finding housing and all. And in the context of the court setting, it gets around a lot of those HIPAA things and all the other confidentiality things that, so I sometimes find myself in status hearings really facilitating discharge plans and or facilitating providers needing to come together and further their relationships with each other and communicating. I mean, one thing I've really learned over the past couple of years is it's all about relationships. It's about relationships with the individual that's before you, but it's also about relationships with the providers, the courts, and the more we develop those relationships where I'm comfortable. I've gotten to a point, there's a couple of Department of Behavioral Health folks and a couple of psychologists that after sometimes I'm like, well, did I really just mess that up? And I want that feedback, and I'm rambling, but I do. So we do a lot of AOT commitments come out of either crisis stabilization or state hospitals sometimes. But I want to make sure there's the clean handoff there. I know it's getting a little bit outside of LEAP, but it's a pretty important thing for making my program work.
We do have a mechanism for making sure we get the right handoff. For example, the hospital on a combined order is required to notify the community mental health system 5 days before discharge in order to have that handoff. And so we had a case where that didn't happen, and the judge ordered a contempt hearing for the hospital. So the hospital attorney shows up and says, well, we're sorry. And the judge says, well, what are you going to do about it? And we're going to have a new policy. He says, I'll adjourn the contempt hearing, come back with a new policy. And by the way, where is this gentleman? Well, we don't know. Well, that's the problem. So the court's not, we're in a position to monitor these handoffs at the different points, like from the hospital to CMH. The CMH is supposed to file the treatment plan with the probate court within 30 days. If that doesn't happen, we step in. We're able to find out whether a person is getting services within 30 days. And we know which providers are providing us have actually engaged with services. And we're hit our best providers is 75%, which doesn't sound right, but it was zero before. So but I mean, I will on occasion get a little more involved with a case. I mean, I had a case where the police department filed a petition for outpatient treatment only, and it was on Zoom, and 8 police officers show up, and they said that the young man had been basically following the police around, shining flashlights on him and so forth at night. And he had been arrested in Detroit carrying a handgun. So it's a very dangerous situation. He has a doctor, but he hadn't been seeing his doctor. So, the statute says that the police have to, in that situation, have a psychiatrist to testify, which they did not have. So I said, well, after a long conversation, I'll adjourn this hearing. If you go and get back to your doctor, and we'll dismiss the petition. And so a month later he comes back, and only one officer that time, he said he's on his treatment now, we're having no more problems. So there is a time to engage, I think. It's just we don't do it very often.
Well, I mean, and actually, that's something I've learned from both in being involved with TAC and being involved with some of the national guardianship. The laws are so different everywhere in the country well, I do think this is a helpful conversation. Some of the things that I'm talking about are not even possibilities where you all are, and vice versa.
I have a question. All of our patients have been outpatient. We don't have a hospital. We've had a few from the jail. And our status meetings, those that are really doing well, they tend, like you said, they tend to be kind of a pat on the back. You've developed that trust. But those cases that are just kind of falling through the wayside, you're getting the reports, they're not doing maybe a third of what they're supposed to be doing. What are some of the techniques that you kind of use the stick versus the carrot? I mean, that's where I feel like I'm not the best at, or does my question even make sense?
Does anyone want to jump in on that one? Go ahead.
I can tell you one of our judges in Genesee County does. They bring the person in for a review if they're non-compliant. And she's usually able to talk them into treatment, because she tells them, I have so much faith in you, and it shakes my confidence, and I worry, and blah, blah, blah. She manages to get them to get into treatment for the most part. If she can't make it happen, then they're transported to the hospital for an evaluation as far as whether they require hospitalization. And then they'll tell the patient, look, if you get this shot, you won't be hospitalized, which is a true statement. If the person says, I don't care, I'm not taking the shot, then if the person does not require hospitalization, they're just released. But they know that this person's going to decompensate, and there will come a point in time where they'll meet the criteria for hospitalization, which is higher than the criteria for outpatient treatment. And then they'll be transported to the hospital and start the process over again. But if you can pick up 90% compliance, it's
well.
great.
That's really amazing. That's awesome.
What goes through my mind is, if you have 90% compliance, then maybe some of those folks don't even need an outpatient order. I mean, that, or at least that is it. But, and to talk Georgia law real quickly, Wes, you do have the option of the order to apprehend non-compliant individual under 37-382, which is similar to what Judge Mac's talking about.
The 1053, I guess, or Yeah.
Well, the order it's a separate, and that can be done without having to have two people do a lay affidavit,
Yeah,
but
that's
just
right.
just alleging that the person has violated the order. Um, my philosophy over time has moved considerably from sticks to carrots. Um, I before learned more about it and TAC and anosognosia, I had a misbelief at one point that you could, with enough medication, people would develop insight or understanding of their illness. Which I, and so, and this was also my predecessor, probably a lot more aggressive on forcing folks and really coercing people to take their medicine. But what I've learned over time is that might work for a little while, but it's not going to lead to long-term adherence. So I've really moved away from that. I have now from time to time, I had one individual that was in AOT, and and she wasn't taking her medicine. I tried using leap techniques. She was always wanting some kind of herbal remedy and other things along those lines. She decomped to the point that she grabbed a sheriff's gun, and needless to say, that did not go well for her. I think she caught 18 charges at that point, and then she continued to decomp in the jail to the point that um, I did some things working collaboratively with the criminal prosecutors and the judges about getting her out of the jail and back stabilized. I feel badly that I didn't that I let that go so long without having a hearing about whether that individual could make informed consent and some of the more aggressive things that I have in my tool belt of things I can do as a judge. But so I so it's always a balance and it's an individual thing. Like as I said, with that individual, I'm um well actually at this point, this is an interesting aspect of it. She's been stable now. She's doing really well. She's a night and day person when she's on her long-acting treatment versus when she's not. Um, she probably didn't meet criteria. Well, no, she didn't meet criteria that she's doing so well for an assisted outpatient order. But one of the other things that we've been working on here is using AOT as an alternative to criminal prosecutions. So she voluntarily requested that she be placed under an AOT order. Her public defender was not upset about that at all because they saw the supervision with AOT as something that would incline them to dead docket that aggravated assault charge or whatever she had originally called. I don't know if that fully answers your question, but I mean, that's where bringing folks in, trying LEAP. If it doesn't work, eventually you have to go to the stick aspect of it. There's an individual right now yeah, okay, Judge Brown, now I'm going to think about it. I'm going to go have lunch with an individual at a private psych hospital because because I'd like he's been at the hospital over 6 months. There's a question about whether he's malingering or whether it's conversion disorder or a lot of other things, but getting him to apply for Social Security is an important thing. And so that is where I'm going to with that individual, I'm going to try to build that relationship again, and we'll have status hearings. But the stick for me when I sit down and talk with him, it's going to be I'm going to use LEAP techniques. I'm going to probably brush up on what some of the things are. There is a stick out there that he does not want to be transferred to the state hospital. And if we can't make progress, then there's going to be no choice. So I want to work with him about not having him transferred to the state hospital, but he also will know that I'm the person that can authorize that. I don't know. as I said,
I'm
that's
just gonna just chime in here real quick because I think that it's sometimes difficult to define roles in the AOT court process. And I do mental health court and I have an AOT court. So I'm really going back and forth between those and then my other court. In an AOT court, I don't think you really have a stick per se. In mental health court, I do because their option is jail or mental health court. But with AOT court, we have some who've come in, but the charges have been dropped because they have to be in Texas. They have to have either the charges are an abatement or they're dropped for them to come into AOT court. But I think it's important to rely on your providers to develop these good relationships with these people. And you lean on them and tell them, look, you're not providing the support this individual needs. It's time for you to step up and give them what they need. And you encourage those providers and make them a part of your team, per se. And then they're the ones that are encouraging, that are supporting, that are doing the day-to-day activities with these individuals. And you're just there to basically make sure that they're doing what they're supposed to be doing and encourage the participant to do what they need to do. Instead of calling them a friend, I say we're partners. We
partner.
sign a
That's a
partnership
better.
agreement.
I like that word better too. I think partner makes sense. And I do lean heavily on clinicians before I would ever do anything. This other person, as I said, he's with this one individual. The clinicians, there's complete alienation between everybody involved in this situation, and this was sort of a bit of a, well, let me see. It's all done in coordination with the clinicians. I lean heavily on it, and I think you're right. Partnership is a better way of, in fact, that goes back to using the LEAP terminology too.
Well,
I actually
that's
have.
what Dr. Amador, if you haven't gone to his website, I encourage you to go to the website and watch the videos. To me, LEAP is as much for the judge, for the bench, for the participants in court as it is for the respondent. You know, part of a I'm from Alabama, a nostanosia, we'll just call it that, is that they're sick, they don't know it. And he does a TED talk, and if you haven't seen it, you got to watch it because it helped me so much, even not only in mental health court, but like in guardian conservatorships. When he asks an audience member, he says, okay, hey, you don't know me. What's your name? What's your wife's name? So suppose I come up and tell you that we've got a restraining order in the back we're going to serve you with. If that's really not your wife, that's really not your home, would you believe it? He said, absolutely not. And he went through the litany. Well, if I put you in the hospital and told you that wasn't your wife, would you believe it? What could I do to convince you that the life that you think you have is not real? And he said, there's nothing you could do. And that was very enlightening for me. I'm like Judge Brown. I have a background. I was a psychologist before I assumed the bench. And wrapping my mind around that concept has helped me so much. I don't know if you guys ever have this scenario in guardianships. I don't know what it is. I'll get someone 60 plus years old, usually a female, usually widowed. She has befriended Prince Charles, King Charles, or Elon Musk, and they're mortgaging their house and sending them Amazon gift cards because and I would catch myself trying to explain to the respondent, this isn't real. There's no way that Elon Musk wants you to send him an Amazon gift card. And I thought, surely to goodness. And then it hit me. There's nothing I can say or do. There's no amount of evidence that's going to change their fixed illusion. And so, Judge Lewis, I feel your pain. I mean, I've looked for the stick too, and I have to agree with Judge Brown. In AOT, I don't know. I mean, I can point my finger and
Yeah.
I don't know
Well,
what
actually,
how
Judge
many
Lewis,
folks is in your county, Judge Lewis? You're Muskogee. How many?
No, I'm actually down in Colquitt, you got lower Alabama. I guess we're South Georgia, and we're, a lot of the Atlanta, we're kind of a mental health desert, but the AOT grants really help. We partner with Thomas County, which is right north of Tallahassee. So we're kind of lucky in the sense we have this program, but our state hospital closed down about 15 years ago. It was
and
in
we
this
got all of
area.
your folks.
And that really hurt, as far as, and actually on the budget, they're looking at building we're out of a federal consent decree. They're looking at building a 300 bed facility, to come back. I don't know how long it take to do that, but
it won't be in South
it won't
Georgia.
it won't be a Moultrie. No.
But actually, just to answer be real direct with you, Judge Lewis, about this, and I don't do this. I did when years ago, but your outpatient order orders a person to follow their individualized service plan. If
That's
part of their individualized service plan is that they have to take their medication, you could literally don't do this. But you would have the legal authority to find them in civil contempt and order them incarcerated until they comply with your civil contempt order. Don't do that. But that is something within your purview in terms of at least, well, it's been legally tested because I've done it and the DBHG didn't really like it. I
Yeah.
don't do it anymore. It's not helpful. But I also, one other thing I just sort of wanted to just talk about, I see a huge distinction between AOT courts and accountability courts. And to me, anyone that has anosognosia is going to do extremely poorly in an accountability court because, as Judge Hassel was saying about being whether or not the person's being married, the other analogy I have is you're somebody that's perfectly healthy, does not have diabetes. Somebody says, I talked to you for 5 minutes and I know you're diabetic, and here's this shot of insulin I want to give you. No, I wouldn't want to do that either. That's the a person that knows they're not mentally ill is not going to ever be accountable. And so that's why and maybe I don't know enough about mental health accountability courts and drug courts in terms of it, but my was that the individual has to have at least some understanding of their illness or addiction for it to really work in accountability courts. I don't know.
A
I could be
psychiatrist.
wrong.
One psychiatrist testifies, we do court-ordered medications, and she says that schizophrenia is like a fire in your brain and that the antipsychotics are putting out the fire. And she describes anosognosia as the condition where the fire has gotten out of control, and so they are not able to see what's happening. But on the correct medications, she said that 7 out of 10 people actually do develop the ability to then adhere, and it's not compliance, it's adherence to their treatment plans at that point. So I think there is some hope for some of these individuals who come to us without any understanding of their diagnosis or their condition to develop that if they're on the medications. And that's why encouraging adherence, I think, is so important.
I agree with that too. Although, as I said, the individuals that really end up or at least the individuals that are going to be in my AOT court on a regular basis are the folks that you're never going to get rid of that fixed delusion, regardless of whether they're compliant. They might be less inclined to act on their fixed delusions, but I'm never, ever going to convince this one individual that she's not married to this person that she ended up spending 5 years incarcerated for stalking. I mean, just never going to do it. So no reason to argue with them about it. I don't know if this has been, it's been very helpful to me to hear y'all's insight into this. Does anyone have any other questions? Does some other things? Because I think we're supposed to cut this short. Well, I think we're supposed to end like a few minutes ago.
I didn't mean to. I've really gotten a lot out of it. I appreciate everybody's input. You know, we're all from different backgrounds, but we're all trying to do the same thing with different type of resources. And it's amazing what Michigan, Judge Mac was there mentioning that. But Mark's
Judge
kind of our
Riddle.
lead in Georgia, and I certainly appreciate what he does in Georgia.
Well, I mean, we all do, and that's another thing. Even in Georgia, we have 5 AOT projects around the state, and and I'm helping in ones that aren't actually funded, expand some to some other communities. But we all have different resources. We all end up doing things differently. In fact, what I really have discovered, in my opinion, is that really there is no one type of AOT. What AOT means to me might be very different than what it means in Texas or Michigan. Judge Riddle, I'm just curious if you have any thoughts about this, given I don't think Cobb County is really doing much of this. You're on mute. You're still on mute, Tara.
I have to apologize because someone just came in and had me sign an emergency order, so I had to shut my camera off and not listen for a second. So what are we talking about right this second?
I was just curious about your thoughts about our conversation here from because as far as I know, Cobb County is not doing any kind of assisted outpatient treatment.
No, we're not. I mean, we do lots and lots of guardianships and OTAs and mental health and voluntary commitments, which sometimes have an outpatient, component to it. And the thing that drives me crazy, and I think you all might agree, is we will do a mental health hearing and on a commitment, and they will suggest outpatient, and the outpatient plan is like seek treatment. It's very generic and it is very difficult. So I make them go back and give me a better plan because they're setting up the patient to fail. If they say, go out and, you need to go find a therapist and do it 3 times a week and do this. And I'm like, where? How?
And that's actually make them bring the provider, make them bring the provider to the hearing. Tell the attorney.
We don't do that, but yeah.
I mean, that's usually how I'll and it depends if there's, again, it depends on how quickly the discharge is. We can continue the matter for a week, and I'd like you to subpoena the providers and the person from the housing specialist from the Department of Behavioral Health. As I said, that's sort of one of the ways of doing it. I do think, as a closing thing, a lot of the techniques related to LEAP are very much transferable to guardianship hearings too.
Mm-hmm. And just so you know, the order I was just signing, we have a guardianship tomorrow where the ward just got picked up today from law enforcement. I got arrested, so we were doing a production order because they want to attend the hearing. So those fun things happen, to everyone too.
I actually have been working on a UCCJEA issue, believe it or not. Miami, Florida has a custody or has some kind of domestic relations things, and we have a temporary guardianship of a minor. But well, anyway, is there anything else anyone wants to add? I really appreciate y'all putting up with me.